Hello, this is Matt on the Moon Lambo channel, and I've got an update for you regarding, I'd say, the most prominent lawsuit against Ripple at this point. And I read through several articles on this topic, and not that any of them were particularly horrendous, but I will tell you that an XRP community member named Leonidas, who runs XRParcade.com, from my perspective, provided the most thorough and well-written examination of what's actually going on here. So I'm actually going to go ahead and run through this one with you and share some of my thoughts on this. But you can see here, Daily Hodl, for example, here's their headline: "Lawsuit that Ripple says could tank XRP will move forward, judge rules." Here's a headline from you today: "Ripple faces major legal defeat that spells trouble for XRP." And there was another one from Bitcoinist that I don't have pulled up. And so anyway, it's all over the world of crypto today. So we're going to dig into this. But before going any further, if you would please delicately tap that like button. And if you are a fan of Ripple and XRP, and perhaps you also agree that there's no chance in hell that XRP is a security, go ahead and subscribe to the Moon Lambo channel. You'll be in good company here. This is an XRP-centric channel. So let's go ahead and dive in. Here's the tweet that caught my attention from Leonidas on the screen here. And there's all sorts of comments, which I may or may not take time to run through. It was kind of an interesting thread, but I want to definitely start off with this, and I don't want the video to go too long anyway. But Leonidas titled his piece, "Zakhanov vs. Ripple, Motion to Dismiss Granted and Denied in Part. Unregistered security allegations remain." And you may notice that that title sounds more specific and less scary than perhaps the other two that I read to you there. So let's go ahead and dig in. Ripple has been in courts ever since Coffee filed a lawsuit claiming Ripple sold unregistered securities. That case was dropped, but other cases emerged. Zakhanov, Greenwald, O'Connor, that were eventually consolidated into one. And he's got this list of the plaintiff's complaints, and I think it gets a little too legal sounding, and it would be too time consuming to read all of them. But in part, here's what he wrote. On August 5th, 2019, the plaintiff filed the operative consolidated complaint against defendants. In it, the plaintiff alleges the following claims. Again, I don't want to go through all of this, but it's basically, here's one. I'll read one. Violation of Section 12A1 of the Securities Act, Title 15 U.S.C., blah, blah, blah. You can see, I don't want to go through all this. Against defendants for the unregistered offer and sale of securities. And most are more or less in line with that type of communication there. So let's go ahead and jump down a little bit. Ripple filed a motion to dismiss the case in December, and after a hearing on January 15th, the Honorable Judge Phyllis J. Hamilton took the matter under submission, meaning that she would take her time to make a decision. And yes, she did. Indeed, it's been 40 days, right? That's what he cites here anyway. So 40 days later, and the judge has reached a ruling. The court decided to grant in part and deny in part the defendant's motion to dismiss the case. And you're not getting these details, generally speaking, from mainstream crypto media. And I know, I read, like I said, several of these things. So more specifically, the motion to dismiss causes 1, 2, 3, and 5 is denied. The motion to dismiss cause 4 is granted with leave to amend. The motion to dismiss cause 4 and 7 is granted with prejudice. And so there were 7, and these were the causes here that I said I didn't want to read through because it just gets too into the weeds for the sake of a video like this. But feel free to check out XRParcade.com if you're actually that interested. I think it just would be overkill here. But anyway, so specifically that's what he was referencing there. So what does this all mean? Well, the charges for misleading advertisements have been dismissed. Those are causes 6 and 7. Along with the charges against Ripple and Bragg Garlinghouse for control person liability in connection with the defendant's primary violation, cause 4. Now, causes 1, 2, 3, and 5 out of the 7 that claim Ripple sold unregistered securities and that misleading statements were made stand. Now, that's not some sort of ruling. It just means that they stand and will proceed here. And so, again, don't forget that there's nothing wild going on here. It's just that Ripple chose to file to dismiss the case. That's what they were hoping for. Dismiss all of this, and it's not happening in its entirety there. They could have chosen not to make that motion, and so then we wouldn't be having these headlines, but they made a strategic a decision there, and okay, that's all well and good. Now, the court will allow the plaintiff 28 days from the date of this order to file an amended consolidated complaint accounting for the deficiencies in the claims dismissed without prejudice, and that's claim 4. In it, the plaintiff must specifically set forth any alleged misrepresentation used to support any amended claim. Failure to do so will result in the dismissal of such claim with prejudice. The plaintiff may not otherwise amend his complaint absent leave of court or consent of defendants. Upon the filing of any amended complaint, the plaintiff must also file a red line clearly demarcating. Yeah, I'm saying that right. I think I'm saying it. Demarcating its changes from the existing complaint. We must not forget that the primary argument behind Ripple's motion to dismiss the case was that the 3-year statute of repose had expired. So listen to this. This is significant. Ripple did not argue whether XRP was a security or not. Now, of course, they've spoken on that quite publicly, but that's not what this was about here. Now, while Ripple and XRP investors would rather see this case dismissed, having removed 3 out of the 7 claims is a small victory for Ripple, but not the victory it hoped for. This case is yet to be decided. So while I agree, it's certainly at a minimum a small victory. It's certainly not being displayed as that in the world of crypto here. And so, as far as whether or not XRP is a security, I always go back to this concept because it's interesting, and existing United States legislation doesn't, or regulatory, from a regulatory perspective, just doesn't really consider this, but cryptocurrency assets, they're unlike any other assets out there. They can change from decentralized to centralized or from centralized to decentralized. And I've reported on stories as of late where the SEC has really come down with the hammer on a lot of ICOs out there that really were getting out there primarily in 2017, some in 2018, but most of them 2017. And some of those didn't go so well. Do you remember this story I just covered here? Let me just pull this up. I'm not really going to run through it, but I covered this within the last week. ICO project Enigma settles SEC charges over $45 million token sale. And they ended up paying a $500,000 penalty. And you're just not seeing the SEC go after Ripple with the claim that XRP is a security. And so why is that? Why is it that XRP has gone untouched from the SEC for the entirety of the existence of XRP for 7 years here? Well, part of it comes down to humans being humans here. Now, you could make a case, and I'm not stating this is the case, but you may recall that Jay Clayton with the SEC, for example, he cited that Ethereum probably used to be a security, but now it's sufficiently decentralized and is not. You might be able to make that case against XRP. I'm not saying that it is, but there's no sufficient regulatory framework in place to really guide that, and the SEC isn't moving forward at exactly a quick pace here. And so you could imagine, what if they declared XRP to be a security, and then down the road they actually did one day have sufficient regulations in place to determine whether or not a cryptocurrency is a security, and what if they had grown to the point where they actually factor in that cryptocurrencies can teeter-totter back and forth. It can be centralized and then decentralized, and vice versa. Well, you could imagine that, given that's the case with Ethereum and certainly XRP, that it's capable of teeter-tottering back and forth between, in theory anyway, certainly, decentralized versus decentralized, centralized versus decentralized, rather. You could imagine what that might look like if you're with the SEC, say you come down on XRP, and then you have regulation that makes it clear that cryptocurrencies can go back and forth between one or the other, and then so maybe new cryptocurrencies moving forward wouldn't have the hammer come down on. But what if the hammer did come down on XRP? Then we say, wait a minute, you came down on XRP, and now years later this legislation exists, and inside of that framework it makes no damn sense to have come down. And I think that these people in the SEC working there, they're very conscious of this, and they're hesitant to make big decisions in part. Now, for the instances where they came down with those ICOs, those decisions are much easier because they never got to the point, those ICO projects, where they went from centralized to decentralized, but Ethereum did, and I wouldn't be surprised if it's the position internally, even if they don't verbally state it, that they believe that XRP maybe was centralized to some degree, and XRP Ledger now isn't. And again, this is just a fun little exercise in speculation. And I'm not stating one way or another that that is or is not the case. But I know that the SEC is thinking along those lines in general because they cited it, Jay Clayton cited it specifically with Ethereum, and I don't believe for a moment that they're only thinking about it in such terms with just that cryptocurrency. I bet they're looking at XRP in a very similar fashion. And things change. And so there you go. Now, in other news here, take a look at this. Steven Seagal charged by SEC for promoting 2018 ICO. So this goes perfectly with this story, and I had to highlight this. The Securities and Exchange Commission, SEC, has charged actor Steven Seagal for promoting an initial coin offering, ICO, without disclosing that he was paid for it. He was ordered to pay back over $330,000 to the commission. In March 2018, Steven Seagal was contracted by ICO project Bitcoin 2 Gen, B2G, to promote the sale on his social media channels, as well as appearing as a brand ambassador in the project's marketing materials. While he was promised $250,000 in cash and $750,000 in B2G tokens, the February 27 disclosure by the SEC maintains that he only received $157,000 from his potential promotional deal. The actor agreed on settled charges with the commission, promising to pay approximately $330,000 to the commission. The sum corresponds to double the amount he received from the project plus $16,000 of prejudgment interest. The SEC specifically targeted Seagal for failing to disclose that his endorsement of the project was paid for, which is a direct circumvention of its regulations. And here's a quote: "Celebrities are not allowed to use their social media influence to tout securities without appropriately disclosing their compensation." And that was noted by Christina Littman, chief of the SEC Enforcement Division's cyber unit. So we'll keep following the saga as this all unfolds around Ripple and XRP, but I just don't believe for a moment that XRP will ever be declared a security. And frankly, even if you believe it used to be, and I'm not saying that it was, it's certainly not today. XRP is the ledger is decentralized, and Ripple has no special permissions over the blockchain, period. That's it for this video, though. I am not a financial advisor. Do not buy or sell anything, because of anything that I say or write, that would be a very, very, very bad idea. Until next time, to the moon, Lambo!